My name is Don Sherman. I have here with me Mr. Don Susantha Katugampala, who is a lawyer and accredited immigration law specialist and founder of Fairfields Lawyers in Melbourne. Good to have you here.
Aiboan Don.
Aiboan. Been in the industry more than 2 decades. Now, when you consider recent changes of employer nominations visas, how do you see that in the current applicants or the people who like to apply on this category?
Effective from 25th November 2023, the changes have occurred for employer-sponsored visas. Two parts. Temporary skill shortage visas, TSS, subclass 482 visa, had two different skill occupation lists. People are on temporary skill shortage visas, subclass 482 TSS. These visas are granted with the support, sponsorship and nomination of an Australian employer. Okay. There are many workers in Australia on these temporary visas. These visa holders come to Australia on two occupation lists, a long to medium term occupation list and short term occupation list. If you held a visa 482 under short-term occupation list, you are unable to apply for another extension in Australia under the previous law. However, with the changes effective from 25th November 2023, the applicants can apply for their extension of the 482 visa without departing Australia, onshore in Australia. That's the good news. If you're on a long-term occupation list 482 visa, the new visa is given for 4 years. Short-term, it's 2 years. It's 2 by 2. And the 4 years visa can be extended for another 4 years. There's no limit. The most important thing is whether you arrive in Australia on a 482 visa, regardless of your occupation, whether you're on long to medium term or short term, you wish to obtain your permanent residence visa. You want to get your PR. That's the dream of the applicant. When you come to this country, most of people want to stay here. So if you want to stay in Australia, then you need to be able to apply for your permanent residence under employer-sponsored pathway, subclass 186. The laws change now. From 25th November 2023, you will be able to apply for your 186 visa under TRT stream, regardless of whether your occupation is on long to medium term or short term. That means that it's an opening for the visa holders of 482 to apply for their 186 visa under TRT stream. It's a good news.
That's a very good news.
Not only that, in order to apply for your PR 186 under TRT stream, you need to have held this 482 visa for 3 years.
Okay.
Now that's changed to 2 years effective from 25th November 2023. That's a good news. So the 3 years been reduced to 2 years. That means people can secure their PR rather quickly than waiting for 3 years.
Yeah.
If your occupation is on a long to medium term list, only you can apply for your direct 186 visa. If your occupation is on the short term list, you aren't able to apply for your 186 visa direct entry stream. It has to be TRT stream to secure your 186 visa. So it's pretty technical.
I know.
So as long as you understand the technicality, you understand this complex immigration law, then you can get your 482 visa. Also, you can secure your PR either under direct entry stream or transition stream. Opportunities are open for employer-sponsored migration pathway.
Well, that's a very good news with the new changes. But if I ask you that why the employer's nomination visa is very important and very popular, I would say very interesting to many people when you compare with the other visa classes.
So these visa classes under skilled migration are only by invitation. Because if you want to apply for general skill migration, you need to have an invitation from the government to apply for your visa. And you need to go under independent skill pathway, or you need to apply for a state nomination from a state territory government. You need to be sponsored. So hundreds of thousands applicants apply for this expression of interest. You are in a pool and you're competing against each other, and you need to have an invitation to apply for the visa. You can't just lodge an application. It used to be possible under the old system. The government introduced a system more than 10 years ago now to avoid refusals. That means you select the applicant before they'll be able to make an application. Highly competitive. But if you want to apply for employer-sponsored pathway, you don't need an invitation to apply because you have an Australian employer to sponsor you, nominate you. So if you've got an Australian employer to nominate you, you have the strength to apply without an invitation. It's an advantage that you have. So you can secure your migration, either an employer-sponsored temporary visa, TSS visa, or permanent visa, either TRT, transition stream, or direct entry stream, on your own. And you can apply independently without an invitation. And if you are in Australia on another visa, you can hold a bridging visa. And then the bridging visa will allow you to remain in Australia, may be able to work in Australia, work for the employer. This is to fill the skill shortage in the country. That means this is an employer-driven visa pathway. The employers need to call the shots. And the employer can nominate someone in order to keep that person in Australia. That's an opportunity. So it's probably the best opportunity at this point of time.
Absolutely. So in that regard, as a law specialist and the founder of Fairfield's Lawyers, what's your role in regard to this one?
Employer nomination pathway is quite complex, and it involves the approval of the sponsorship, approval of the nomination, and the visa. There are three components to it. And sometimes instead of the sponsorship could be a labor agreement, an agreement between the employer or the sector of the employers and the minister, the Australian government. As a lawyer, what we do is we negotiate with the employer. We represent you to your employer. Your employer supports you. So we have the absolute capacity and the negotiation skills to support your case in negotiating with the employer in order to secure the required documentation, and then represent you to the Department of Home Affairs and lodge this application. And in certain circumstances, we can obtain age waivers under DARMA scheme, where the designated migration agreement is applicable for regional migration. All that can be done. It's not just giving the correct immigration advice, it's the negotiation with the employer and the department to get the right outcome for you. That's our role. Because our preamble, our principle of Fairfield's Lawyers is deliver results. We deliver results. So the results, outcome in your immigration matter is the most important thing.
Thank you for the valuable information given today, Mr. Don Susantha Katugampala, the founder of Fairfield's Lawyers, Melbourne, Australia. Ayubowan.
Ayubowan Don.